Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 130 from very snowy London. Although I strongly suspect that anyone listening outside London will be thinking, call that a snowfall? Anyway, we have three cases for you today, of course. The first is a case that was actually decided back in 2015, but has only become publicly available now, and I think an embargo on the decision was lifted. Secondly, we've got a case on employers' discretion and the extent to which an apparently unfettered discretion is actually fettered by law. Thirdly, we have a case on collective redundancy consultation and the point at which the employer has passed the trigger point for collective discussions. Then at the end, I want to tell you about a very special podcast that we're recording next Friday, although I'm not entirely sure when it's going to go out. Stay tuned for more details. I also have the statutory cultural reference and recommendation as well. As always, you can access the podcast via iTunes, it's on the Mayor Brown website or YouTube, and the Twitter feed Nicholas Robertson at Nicholas ROBER11, which is also where we post out links to all of the cases discussed. So, first case in Dyson Technology Limited and Pierre Pelleray. This is a case dealing with the enforcement of a non-competition restrictive covenant and for a springboard injunction, I think, and I apologise for saying this live on air, it's a really interesting case. And anyone involved in enforcement of restrictive covenants or springboard injunctions need to read it carefully. Certainly seems, I think, to open up a number of opportunities for employers. And I find myself in respectful disagreement with two High Court judges and Paul Goulding QC, a former guest on this podcast, of course. So let's see how well I get on with that. Anyway, I want to go into this in a bit of detail, but I'm not going to be able to deal with all of the aspects of the case in this podcast, so I'll deal with some bits in summary. And I'll deal with the non-competition restricted covenant more briefly, because I want to say a bit more about the springboard injunction. The background to this is that Mr. Pelleray worked for Dyson as an engineer on various projects, including working on electric motors for Dyson vacuum cleaners. The contract which he signed on joining Dyson had, as you'd expect for someone involved in this situation, hefty clauses dealing with an obligation to maintain confidentiality, a clause requiring him to use reasonable endeavours to promote the interests of the company and act in good faith in relation to it. There was also a provision prohibiting him from working for a competitor for 12 months after leaving, or 12 months after he was put on garden leave if that produced an earlier date. A competing business was described as being one which was similar to a business being carried on by Dyson or a Dyson company in which Mr. Pelleray was involved during the last 12 months of employment, or for which he had material information. It also went on to say expressly that in circumstances where a new product was to be launched by Dyson, if Mr. Pelleray was involved in the planning, researching, etc. of that in the 24 months prior to leaving and had confidential product information at the time of leaving, then this too was viewed as being a competing business if the company he moved to was already in that area. That's important, so I'll come back to this. Takeaway point for the contract is that it's obviously a well-drafted contract and with focused restrictive covenants. In 2014, Mr. Pelleray was approached with a job offer from a CCTV company in London. He told Dyson about this, and in response, Dyson put up his salary and promoted him, which he accepted. In November 2014, however, he was contacted by a recruiter from Tesla. They were interested in him because of work that he'd done before joining Dyson. He had an initial interview in December 2014, telephone interview January 2015, went for interviews in Palo Alto in February 2015, got a job offer in March 2015. Why is all this relevant? Well, for two reasons. First of all, in the 2015 interviews in February, he was asked about his expertise, and he gave a relatively general answer, but said, amongst other things, that he was working on the latest Dyson digital motor, and he provided a couple of details around its revs per minute and efficiency rating. This was not generally known to the market at the time, so it was confidential information. There was a revised job offer issued to him in late March, which envisaged him going to work in the United States with a start date in August 2015 by Tesla. However, matters then took a turn, because in May 2015, i.e. 2 months after he provisionally accepted the offer with Tesla, and whilst Tesla were trying to sort out his US visa, Mr. Pelleray was taken to one side and informed at Dyson that he was going to be working on Project E. This was a development by Dyson of an electric car. Pausing there, of course, you will know that Tesla is already in the electric car market. The evidence is that, from that point, it was going to be about 4 years before Dyson actually got an electric car in production to challenge Tesla, indeed if it all got that far. Mr. Pelleray decided not to say anything about his job offer from Tesla or his proposed acceptance of it, and so the early stages of the project went through with him involved in the Dyson project, Project E. So 27th May, he's moved on to Project E, and on 15th June, some 2.5 weeks later, his job offer from Tesla having been sorted out, he went and handed his note in and said he was going to work for Tesla. Dyson were unimpressed. They got their lawyers to write to him directly, saying, given that his proposed new employer is engaged in the same sort of business as the business comprised in Project E, therefore he would be involved in direct competition. The letter was headed confidential. Unsurprisingly, Mr. Pelleray told an in-house lawyer at Tesla that he'd received this letter, and the in-house lawyer assured him it was okay to send the letter on to him. Of course, the Dyson letter to Mr. Pelleray revealed the existence of a Dyson project to develop an electric car. Although the lawyer indicated he'd not passed on the details to anyone else, the fact remains that there was a second, maybe low-level, and inadvertent breach of confidential information rules by Mr. Pelleray when he passed that letter on. Litigation got underway, and there were 2 separate claims by Dyson against Mr. Pelleray. The first was that there would be a breach of the non-competition 12-month covenant. The second was that Dyson sought a springboard injunction on the basis that when Mr. Pelleray was first asked to be involved with Project E by Dyson, he did not tell Dyson that he'd accepted a conditional job offer with Tesla. I'm going to come back to that, because I think that's very important about this case. The non-competition covenant turned to a significant extent on the precise wording, so there were some quite specific points that were of less general interest. There were attempts to convince the court that the wording itself were unreasonable, the period was too long. But in terms of the key points, maybe of wider application, one of the more interesting challenges, one of the arguments put up by Mr. Pelleray, was that Dyson would not be involved in the electric car market for nearly 4 years after he'd left. Remember, it was going to take that long to actually get the car into production. The non-competition period ended after 12 months. In the circumstances, he argued, it was not appropriate to grant a non-competition injunction. However, I think the well-worded covenant assisted Dyson because it covered the development of products to compete with a third party. Moreover, the court accepted that in circumstances where an employer was looking to enter into the market, it could be damaged by an employee going to a company that was already established in the market. There was also an attempt to say that the Dyson corporate vehicle for which Mr. Pelleray worked was not the same as the one that was selling the electric car, and therefore there was no protectable interest. But the fact that Dyson Research Company made its research products available to other Dyson companies meant that the employer here, the research arm, had a legitimate interest to protect. Finally, both Tesla and Mr. Pelleray were pains to emphasise that they had no interest in leaking Dyson's confidential information and were willing to give appropriate undertakings to that effect. But the court made 2 powerful points in response. First, the covenant was partly to guard against the risk of inadvertent disclosure. Here, they had 2 examples already of inadvertent disclosure by Mr. Pelleray. There's no suggestion he deliberately set out to disclose it, but nevertheless, that's what had happened. It would be impossible for Dyson to police Mr. Pelleray once he was working for Tesla, and damages would be a wholly inadequate remedy if there was any leak. Therefore, the non-competition covenant injunction was granted. However, it's the springboard injunction that I want to talk about as well. There was a clause in Mr. Pelleray's contract of employment that said, quote, "You agree that if any person approaches you in connection with offering you employment, which is, or potentially may be, in competition with the company or any group company, then you will immediately inform the company of that approach." Unquote. The court made a number of key decisions. First, it said that such a clause was not in restraint of trade. They did so relying on the very well-known Tullett, Prebon and BGC Brokers case from a few years back. The judge said he also took comfort from the fact that Paul Goulding QC, in his Employee Competition Book, bracket 2nd edition, indicated that the clause did not limit an employee's ability to take up a new job, just required employees to be open about their plans. So, the judge found that the clause requiring an employee to disclose an approach by a competitor was not in a restraint of trade, therefore it didn't need to be justified as being reasonable. Secondly, the court said that even if it was in restraint of trade, the clause was reasonable. The approach had to be from a competitor rather than just any employer. Moreover, the employer's response might be to raise salary, provide more benefits, promotions, etc. And the court pointed out this is what had happened to Mr. Pelleray when he'd previously disclosed an approach from another, I think, non-competing employer. The judge then went on to consider whether to grant an injunction based on the failure to disclose what had happened before or at the point when Mr. Pellery was asked to join Project E. And the judge accepted that an injunction in this case was to prevent future breaches and further loss. It was not to punish past breaches. So there had to be some sort of ongoing advantage. Well, here, of course, Mr. Pellery had been made aware of certain amounts of confidential information consequent on failing to disclose the conditional offer that he was sitting on. The judge said, in many cases, if there was simply a breach of the notification clause, it would be difficult to see why an injunction would be granted. I'm going to come back to that. However, here, as I say, confidential information had been passed to Mr. Pellery following his failure to make disclosure. On that basis, an injunction would be granted. The court went on to say that in principle, given that we're talking about confidential information having been obtained, the injunction could last until the information ceased to be confidential, which could be many years down the line. But since the claimant was only asking for a 12-month restricted period in line with the non-competition covenant, the court said it did not need to take that point any further. So why do I think this is very helpful for employers but also somewhat troubling for employees? I think it's absolutely clear that contracts of employment for all senior staff now need to include a clause in similar terms to the Dyson clause. I accept the facts of this case were particularly unfortunate for Mr. Pellery. Whilst he was sitting on an offer from a non-competitor, the position changed, so the company he was going to join became a competitor. But I think this case has rather more implications. First of all, let's deal with the argument as to whether or not such a clause is a restraint of trade. I am conscious, and with the greatest respect, that there is weighty authority indicating that what I am about to say is simply wrong. But a restrictive covenant is, broadly speaking, something which has the effect of restraining competition. This clause required an employee to disclose an approach by a competitor. If that's all it required to be disclosed, then arguably it's not a restraint of trade. But bear in mind here that the judge recorded was not that he had failed to report the tapping up by Tesla back in December 2014, or that the tapping up had occurred in May 2015 when they asked him about Project E. The judge records the Dyson complaint to him as being the failure by Pellery to disclose that he was sitting on a confidential offer of employment. Now that's not tapping up, that's more information. Now, pausing there, factually, it's entirely understandable that Dyson wanted to know he was sitting on a confidential offer of employment. An employer would want to know that the employee was considering taking up, or had taken up, or was in the final stages of negotiation of an offer. The mere fact that I tell you I've been tapped up by a competitor, and I provide no further information, doesn't tell the employer what steps should be taken. Imagine here, if Mr. Pellery had simply said to his employer, "Oh, by the way, back in December 2014 I was approached," full stop, says nothing more. In this example, he didn't say anything about the confidential offer he was looking at, the interviews he'd flown out for, etc. Clearly, the employer is going to be very unhappy about the selective disclosure. So I think actually the impact of this clause, coupled, as Dyson put it, with the duty of mutual trust and confidence, implies that an employee, once they have said there's been tapping up, is expected to say if they're looking at taking up the offer. And I think that's clearly a restraint of trade. How many employees are going to feel comfortable disclosing to an employer that they might be leaving them? The damage done to the employer-employee relationship is self-evident. So employees will be less likely to follow up alternative offers. There's less likely to be competition for employees. Anyway, as I say, three weighty authorities against me, but when you look at what this clause actually required this employee to do and the nature of the Dyson complaint, I do think it has an anti-competitive effect. Obviously, if it is a restraint of trade clause, then it merely has to be shown to be reasonable. Again, I entirely understand why employers would say, look, if the head of department is tapped up by a competitor, it's a reasonable assumption that they may be looking at other hires from the same team. Therefore, we need to get our act together towards those other members of the team so that we don't have a team move. All very sensible. But does an employee have a right to privacy under the Human Rights Act, Article 8? Is the desire to follow a particular career path by itself something an employer is entitled to corral by forcing the employee to disclose his or her thinking before any decision is taken? There's no attempt to argue that there, but I'm pretty sure some of our European colleagues would fall about laughing at the idea that an employer could require any employee to disclose not only that they've been approached, but also what they were intending to do about the approach before the employee had taken any decision whether or not to accept an offer. But why does all this matter? They're an extreme set of facts. The judge said in a simple case where there was only a failure to disclose by the employee, no harm will be done, no injunction would be forthcoming. Well, I think the answer to that is this is a really powerful weapon in team move situations, isn't it? The difficulty with challenging any team move is that you know full well that someone somewhere has broken their contractual obligations, but nonetheless it's almost impossible to prove. This Springboard case potentially changes that. In a team move, the one thing you know for certain is that someone will approach someone else about moving. You don't know whether it's the new employer, or a colleague, or a headhunter. None of that matters. According to this case, if you have an obligation to disclose an approach by a competitor or a headhunter or colleague, then the obligation will have been broken. And you could easily imagine a situation where 3 or 4 people move from the desk of a company to a competitor. This clause indicates that at the very least the employer can rely on the disclosure, the failure to make the disclosure about the approaches to challenge the whole team move and say, look, if the first person tapped up had told me they'd been tapped up, I would, as a matter of course, have gone round securing the other members of the team. I have been deprived of the opportunity of changing people's minds or getting to them before they were approached. I have suffered significant loss. The competitor has got a head start unlawfully against me. Away we go. So I think we're going to hear quite a lot more of this case now it's surfaced. And it will be interesting to see whether some of the arguments that I've outlined in this podcast do in fact go anywhere. Anyway, that's the case of Dyson Technology Limited and Pierre Pelleret. The next 2 cases, I am quite sure you'll be happy to hear, are rather shorter. IBM UK Holdings Limited and Dalgleish and others. This is immensely complicated pensions litigation connected with changes introduced by IBM to its pension scheme. As such, I am only going to touch on one of the main aspects of the case, which is to do with implied limitations on a discretionary power granted to an employer. It's also pretty complicated in factual terms, so any summary I give is going to be pretty broad brush. Having said that, the factual background is that IBM came under pressure from 2008 and onwards to increase the value of its earnings per share and improve its asset value. As a result, IBM decided to address this in part by cutting back or closing its defined benefit pension scheme for many employees. This is called Project Waltz. However, crucially, Project Waltz followed on from 2 previous projects cutting back on pension benefits, Projects Ocean and SOTO. Both the trustees of the pension scheme and a number of the beneficiaries were very unhappy about the changes, and litigation was started and eventually reached the stage of full High Court hearing. High Court decided that although the decision made by IBM to introduce the changes was a perfectly rational one from IBM's perspective, it disappointed what it defined as the reasonable expectations of beneficiaries. And as such, this amounted to a breach of the normal duty of trust and confidence imposed on the employer and the equivalent pensions duty, which is known as the imperial duty after the case in which it was identified. Unsurprisingly, given the complications that then ensued, the employer appealed to the Court of Appeal, and the Court of Appeal started off by looking at the implied limitations on a discretionary power given to the company. They were very clear that the appropriate test was to apply the Wednesbury test. This meant looking at whether the decision maker had taken into account all relevant matters and taken into account no irrelevant matters, assuming the employer in this case exercising the discretionary power that it was expressly given under the pension scheme rules. Assuming the employer passed through that part of the test, the question was whether the decision was one that no rational decision maker could have come to. The Court was at pains to emphasise it was not up to the Court to substitute its own decision for what should happen for the employer. The burden of proof is on the employees, the claimants in this case, throughout. The Court said, however, it would need to know about the employer's reasons for its decision and the decision-making process in order to establish whether or not the Wednesbury test is met. Here, once the question to be asked was, had IBM come to a decision which no rational decision-maker could have come to, the High Court decision looked very vulnerable. Remember, the High Court itself had recognised that from IBM's perspective, what it did was a perfectly rational decision. Here, the High Court judge had come to his decision on the basis of the reasonable expectations, the employees' reasonable expectations. These were expectations reasonably held by employees that the employer would act in a particular way in the future, where those expectations were created by the employer's own actions. In particular, the employees contended as a result of the earlier pension cutback projects, Ocean and SOTO, that here IBM had given a clear indication about not acting in the way it then envisaged Project Waltz in the future meant it would act. Obviously, these expectations stopped short of estoppel or warranties or anything of that nature, otherwise there would have been a clearer route. It was the fact that there were only expectations that were reasonable that meant the High Court judge had to erect this whole framework of reasoning when finding that IBM had not had power under their discretionary clauses to make these changes. But the Court of Appeal disagreed. They did not accept that reasonable expectations of the beneficiaries was an overriding factor. It was a factor, it did not have disproportionate weight. Secondly, in any event, the Court went on to criticise some of the determinations of what amounted to reasonable expectations by the High Court and the circumstances in which they would potentially change. In short, I think this case indicates that the Court of Appeal are restoring contractual orthodoxy to the question of how to challenge an employer's discretionary power. It's clearly going to be difficult, and I suppose, thinking about it, it may be easier to show that an employer took into account irrelevant matters or failed to take into account relevant matters. But setting the bar for a successful challenge at the level of no rational employer would have decided what this employer decided is obviously going to be very tough to show. So that's the case of IBM, UK Holdings Limited and Dalgleish and others. So finally, Keeping Kids Company and Smith. This is an EAT decision on the unhappy demise of the Keeping Kids Company charity back in 2015. The issue was whether the employer, the charity, had failed to embark on a collective redundancy consultation in time. The background was that the charity had apparently been in some financial difficulties during 2014 and the early part of 2015. On 12th June 2015, the charity made an application to the government for a grant. There was a business plan attached to this which indicated that more than 50% of employees would be made redundant if the grant was provided. There was also an expectation that the grant would be matched by donations from private philanthropists. If the government was not forthcoming with the grant, it said, then the alternative was the almost immediate insolvency of the charity. And there were some 550 staff at the charity. The government made the award of the grant on 29th July 2015, but the very next day allegations surfaced about safeguarding issues for kids being looked after by the charity. This, in effect, killed the charity stone dead. Within a few days it had shut its doors permanently. Had the business plan attached to the charity's application for a grant in June 2015 been accepted and processed, redundancies would have taken place in September 2015. The Employment Tribunal, by a split decision, decided there had been a failure to consult collectively, there were no special circumstances, and awarded a 90-day award. I'll come back to their reasoning in a moment, but interestingly the tribunal judge was outvoted by the two lay members on it. The tribunal judge would have decided that there was no breach of the legislation and/or there were special circumstances to excuse the failure to consult. The liquidators of the charity appealed to the EAT, and with one exception, EAT rejected their appeal. First, the Employment Tribunal by majority had decided there was a breach of the collective consultation obligations by 12th June 2015, when the application for a government grant was made. The legal obligation on an employer is to consult in good time and not less than 45 days ahead of any dismissals taking effect, where there are 100 or more proposed dismissals. The EAT had no trouble in accepting that it was not permissible to start with the date of dismissals and count backwards 45 days from there to see when consultation should start. Matters may already have rendered consultation superfluous if you could have held earlier, but held off until that point 45 days in advance of the dismissals taking effect. Consultation, moreover, according to the legislation, has to start in good time. So the first learning point is if you're doing this, it's not safe to assume that you only need to consult for the 45 days leading up to dismissal. The 45-day period may well need to start rather sooner than 45 days before the date of the dismissals. Second, the question is whether or not the charity, by the 12th of June, was proposing to dismiss as redundant 20 or more employees. If it was not proposing to dismiss staff at that point, then it was not required to start consultation. By that stage, however, the tribunal found, and the EAT accepted, there were only two options on the table. As determined, either a significant number of employees were going to be dismissed if the government grant was forthcoming, some 250, 300 or so staff, or there was to be an insolvency event and all of the staff would be dismissed. Therefore, by 12th of June, there was a proposed set of redundancies. The EAT accepts, without going into any detail, that if an employer is proposing something, that indicates a step that is, quote, much more certain and further along the decision-making process than the verb contemplate, unquote. However, even on the basis of that test of proposing, if an employer is considering only two alternatives, total shutdown and dismissing 250 plus staff, clearly, the court said, the employer is proposing redundancies at that stage. So there was a trigger point, and the question was then, was the consultation in good time? Remember, there is no longer an obligation to consult at the earliest opportunity. There hasn't been for many years, although that was originally the legislation. Here the employer was, in essence, arguing, even if it could have started consultation on or before 12th June 2015, it was not under an obligation to do so. It was simply under an obligation to consult in good time. Nevertheless, here the Employment Tribunal majority came to a view which was permissible, according to the AT. By the time you're submitting to government that there are only two options, you're effectively saying that consultation over third options, alternatives to making any redundancies, are not going to happen. Therefore, there was a failure to commence consultation in good time because it was not started on or before 12th June 2015. Although there was an attempt to argue that there were special circumstances which excused the breach, namely the child safeguarding issues which surfaced in July, the Employment Tribunal and the AT agreed that was incorrect. That later development could not retrospectively excuse the breach on 12th June. However, and where the EAT did allow the appeal, they asked the Employment Tribunal to reconsider the damages. If the charity was overtaken by events which rendered further consultation useless in early August, bearing in mind, of course, it was anticipating it had up until mid-September if the government grant came through, this was a relevant factor for any damages to be awarded. Although the EAT didn't say this, you could see a logical argument saying that consultation could only have lasted a proportion of the intended 45-day period, or the period that the charity reasonably understood that it had, and it came to an end through unforeseen events. Therefore, a lesser award than 90 days would be appropriate. However, that was a matter that was referred back to the Employment Tribunal by the EAT. The reason I wanted to mention this case is to emphasise the need to be realistic about collective redundancy consultation. First, has the employer got to a stage where redundancies are being proposed? It does not need to be a final decision, but if, as here, the company is choosing between two alternatives, both of which involve collective redundancies, then the employer is proposing collective redundancies. Second, just because the employer is proposing collective redundancies, that does not trigger an absolute obligation to consult at that point. Nonetheless, an employer who delays at that point, commencing consultation, as the charity here did, runs the risk that something comes along which renders consultation futile or of limited effect. The longer the employer delays after the trigger point has been reached, the employer is first proposing redundancies, the greater the risk to the employer that it will be found to have broken its duty to consult in good time. So that's the Keeping Kids Co. and Smith case. So, thank you very much for listening to the podcast, of course. I said I'd say something about the very special podcast coming up. I'm truly delighted to say that I've been asked to host the inaugural Employment Lawyers Association podcast. We're going to be doing an interview with His Honour Judge Brian Doyle, who is President of the Employment Tribunals of England and Wales. I think it's going to be a fascinating opportunity to hear his thoughts about the current tribunal systems, reforms, etc., and perhaps where he thinks matters are heading. If you have any questions you'd like me to put to him, I'd be delighted to do so. So please do get in touch with N. Robertson at mayorbrown.com. And I'll see if I can pick out some of the questions. Once we've done the podcast, then on this podcast, I'll make sure that people know how to listen to the interview. Oh, I mentioned I got a theatre review. I went to the Bridge Theatre here in London last week to see their production of Julius Caesar. It's really, really good. Very immersive, very imaginative, very fast-paced, and very full-on. Think Julius Caesar meets Apocalypse Now with helicopters. Apocalypse Caesar, anyone? Thanks very much indeed for listening.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.